Welcome to Making Money with Laura Sanders, a name you can trust. With over 20 years of real estate experience and selling over 150 homes a year, Laura Sanders is the #1 RE/MAX agent in the state of Florida for 2021. Join us each week as we discuss how to make money through buying and flipping homes, to renting versus selling, and everything in between. To join the conversation, call in live. 888-994-4995, Studio A.
Hi everyone, and welcome to Making Money with Laura Sanders, and I am your host, Laura Sanders. Every week we talk about something that's going to help you save a little money, make a little money, one way or another. This week, how would you like it if you went to go sell your house and you got down to the closing date and found out, guess what? You're not selling it because the buyer is a foreign national. Not all foreign nationals, but a foreign national that would be told you can't buy in the United States. Or I should say, I'm sorry, let me correct myself, in Florida, thanks to the governor. So today we have two amazing attorneys with JK Closings. We have Charles Esposito and we have Nicholas Fiorello. I want to welcome them both from JK Closings. They are very affordable and always available to help you even on a Saturday morning when you have some questions about a transaction. So welcome, guys.
Thanks for having us, Laura.
Thank you.
So there's been some changes to conveyances with foreign nationals. Before it used to just be like a holdback when they're selling of their monies. But now when you go to sell to a foreign national, which we were selling to a ton of foreign nationals, that whole landscape has changed. So tell us, like, what do we as agents and as buyers and sellers need to look out for?
Right. So in Florida, and I want to say about 17 other states, there have been laws that have been passed to essentially block certain buyers from different countries from purchasing land, most notably China and Russia, North Korea, Iran, countries like that. In Florida, basically, buyers from those countries cannot buy certain properties that are located near critical infrastructure, military installations, and in the particular case of China, they can't buy any property at all. So it's something that's making waves in the real estate market right now, and we have to deal with it a lot. They've even added a box into the as-is contract. So right before you go to sign a contract, you're going to see a box that tells you all about this law.
So there's an agent that's in our little local backyard that was staying up all night, and he was calling China all night long, selling them brand new homes in Parkland. Like, how does that work now? Is that over for him?
Well, maybe not. There are some exceptions to the law.
Okay.
And when a buyer calls us up and says, hey, I'm from one of these countries, can I purchase a home? Normally we ask them a bunch of questions. And the important thing that we talk with realtors about is making sure that the realtor is advising their client that they should be talking to an attorney, whether it's us, whether it's an immigration attorney, because there are certain exceptions to the law. So if the person actually is from one of these countries, there is an affidavit that they could sign that states whether or not the law applies to them. They get advice from an immigration attorney, and they might meet the exceptions. So it's not a hard and fast rule that everyone from these countries is going to be unable to buy. There are also some ways around it in terms of structuring companies so that people from these countries are not majority owners of a country, of a company. So there are ways around it, and that's why we always tell realtors they have to advise their clients to speak to an attorney to figure out whether or not they do actually qualify for one of the exceptions.
But the law does apply when there is a principal member of a entity. So you have to be very careful when creating an entity to try to go around the law. Not to say that you should go around the law, but to do that, you have to be careful because there are certain things that could prohibit the purchase at the end of the day and make it illegal.
Right. And importantly too, Laura, you asked about realtors. This law doesn't apply to realtors. It doesn't apply to us as closing agents. It doesn't. It's not even a title issue, but it does apply to sellers and buyers. It makes it illegal for a seller to sell to one of these buyers. So your clients and our clients are notably concerned about it.
So basically, let's just say, for instance, and I'll give you, so the other day you guys were doing a closing, you're doing a closing for me, and one of the attorneys sent an email out asking for them to sign the affidavit. The agent responded back pretty quickly and said that this person is a U.S. citizen. Actually happens to be related to like Ed McMahon. So said, you know, hey, this person is an American citizen. The agent responded for them. Is that good enough? I mean, does that put the liability on the agent and no longer on the seller? Is that suffice by that email?
It doesn't suffice, no. As an attorney, especially one representing a seller, we're going to be making a push to get that affidavit so we're not putting our seller at any chance of liability. When we're representing a seller, we want that affidavit signed or a statement from somebody saying it's going to be signed before closing, because that will inherently release the seller from liability, because we have the buyer signing an affidavit stating they are not foreign.
But in this particular instance, right, a lot of times, you know, and just so you know, agents, like, you just don't need to use title companies for when you're buying, especially in Broward, which we're like one of the 3 counties where the agents don't get to pick for their sellers, but you also represent our sellers. So in this particular instance, you would be sending over an affidavit to the closing agent, and the closing agent's going to say, I'm not going to have my buyer sign your documents. What do you do then?
Yeah. So
I mean, I just feel like people just don't want to work together. Like,
yeah,
nicely. They play
exactly.
nice in
I
the
mean,
sandbox.
we're closing attorneys. We always say this. We like to close. We don't want to fight.
Right.
And it's one of the things we talk about with this law, too. It creates an extra hurdle to closing that, you know, maybe doesn't necessarily need to be there. So when we handle a seller representation, we like to have the affidavit signed because we want the ultimate protection for our seller. The law says that the seller cannot knowingly sell to a buyer from one of these countries. So if we have an affidavit signed by the buyer that says that the law doesn't apply to them, basically, well, then the seller is not knowingly selling it to them. If we just have an email from an agent, that's not really good enough for us. And it might put liability on the agent's hand. It might be considered giving legal advice, maybe, but
the agent giving legal advice?
Yeah, in
Ooh.
terms of interpreting the contract and saying whether or not the buyer qualifies for some sort of exception. That's the agent making a judgment.
But isn't
on
that just
part.
a question you ask on every deal now?
Well, is it a question that we ask,
It's
or
the
is it a
first
question
time-
that the agent
okay,
asks?
So that's the first time. You know, you guys have been doing my seller reps for me for a while. So like, that's the first time that you guys had sent that email out. So I was like, okay, is it that particular deal, had tagged it to do that? Or is that just something you're just getting a little bit more, like this all just happened July 1st. I mean, so what are we,
Right.
July, August, September? I mean, we're not even 3 months into this. So it's kind of like, remember back when TRID, it was like such a big deal. Like
yeah.
same thing, we don't know where to go. And it's like you're slowly getting into the process. And some agents are like, what are they talking about? And it's like, oh my gosh, you're like, if you don't do this every day, like I'm a very well-known agent. And when this came out, I was like, I was getting concerned. And I was going to everybody's training. I went to yours, I went to another, because our office had a couple of different ones. And then it was like, I was hearing something different from this person and that person. And then I was getting confused, and I don't want any liability. And I definitely don't, listen, you say that it doesn't affect the agents, but in the end, if the seller sells to somebody who's not, right? Who are they suing? Me, because I didn't do my due diligence to make sure that they sold it to somebody that wasn't. Like, in the end, I'm going to get named in a lawsuit.
I think the liability is on the seller, and that's where
They're
we're
going to
so
plead stupid.
well. That's where we're so proactive when we have a seller that we're representing, because we want to make sure that that seller is protected, and that's why we're going after that affidavit to make sure the buyer signs that, stating that they are not a foreign individual or a foreign entity or part of a foreign entity to make sure the seller is not breaking the law, therefore not getting sued. And we want the agents to stay away from giving legal advice and trying to interpret the law or the contract. And we can do that by simply getting an affidavit signed, early on.
Well, have they come up with yet on who, shouldn't it be one person or the other that's responsible to have this affidavit signed no matter what? But they haven't gotten to that point yet, right? You guys have created your own affidavits.
So this is what's interesting. I want to go back to something you said in the beginning, too, of this segment, which was you don't want the deal to blow up at the closing table. So, one of the reasons why we provide the affidavit at the beginning of the transaction on the file that you're talking about is I want to know right away whether or not the buyer is going to sign that affidavit, so that if the law does apply to them and they can't purchase, I want you to be able to get your house back on the market and sell it to somebody else.
Right. So
that's one thing. And then, to answer your question regarding whose responsibility is it, the law clearly states that it's the sellers are not allowed to knowingly sell to a buyer who's from one of these countries. And then the law also says that the Florida Real Estate Commission has to create an affidavit, but the Florida Real Estate Commission has not created an affidavit. So it's made it very confusing, especially for realtors, as to what their responsibility is. And I always teach realtors that it's not their responsibility because the law doesn't say it's their responsibility. It could be a Fair Housing Act violation for you to start investigating whether or not a buyer is from one of these countries. And that's why we take it upon ourselves, if we're representing a seller, to just get the affidavit signed, because then we know that we're protecting the seller. So you don't have to worry about it as an agent. Your seller doesn't have to worry about it selling the house. And then we're not representing the buyer in that scenario. So either they're signing it, or if they don't sign it, they're basically telling us that they're not allowed to buy this house anyway. And that's why we provide it.
And that goes back on what you said earlier. When we get an email from another agent saying, oh, the buyer's a U.S. citizen, that's not enough. We want that affidavit signed to completely release the seller from any liability. Because at that point, the seller won't knowingly sell to a buyer because the buyer's stating they're not foreign.
And that's another reason why it's important to use the right people, the right agents, the right title companies, the right attorneys, to make sure that you don't wait 5-6 weeks and then it all blows up in your face because you don't even know about this law.
Yeah, we've been getting emails from title companies, and you mentioned before in Florida, you don't have to use a title company to close. You don't have to use an attorney to close. You can use one or the other. And obviously we're attorneys, and our law firm does closings, and we do everything that a title company does. We received emails from title companies that we work with on the other side of the transaction saying that they're going to make every buyer sign this affidavit at closing. But we don't know whether that's the first time the buyer is going to see that affidavit. What if at the closing table, that's the first time they see it, and then they have no idea whether or not they can sign it? There's no attorney at the title company to give them legal advice on it. Their agent can't give them legal advice on it because they're not an attorney. So now that might hold up the closing simply because they're being asked to sign this affidavit. So we've come up with a structure in our firm for how we deal with that, whether we're representing a seller, whether we're representing a buyer, or we're acting as the closing agent on the transaction to make sure we ensure a smooth closing.
All right, well, hold that thought. We're going to go to commercial break, and when we come back, we're going to continue this conversation, and we're going to move on to some other things that people aren't thinking about either when they're selling a house or a condo. So stay tuned. We're going to see our wonderful sponsor, Max Fish, with Nationwide Mortgage, and we're going to also see our sponsor, JK Closing. So stay tuned, and we'll be right back.
Whether you're buying, selling, refinancing, or building your dream home, you have a lot riding on your loan specialist. Max Fish, a top 1% mortgage loan officer in the nation, will give you a same-day qualifying quote. Max Fish is committed to providing his customers with mortgage services that exceed their expectations. Ensuring that you make the right choice for you and your family is his ultimate goal. Contact Max Fish today at 954-729-6933 or max.fisch@nwmcorp.net.
At JK Closing Attorneys, we do all of the same things that a title company does, but with the benefits of being a law office. We can help with residential real estate, short sales, commercial real estate, refinances, 1031 exchanges, and FRIPTA withholding.
Contact JK Closing Attorneys today at 954-332-3111. Again, that is 954-332-3111.
You have been watching Making Money with Laura. For more information, contact Laura Sanders at 954-650-0827 or visit her website at theloracell.com. And now back to the show.
Hi everyone, and welcome back to Making Money with Laura Sanders, and I am your host, Laura Sanders. So we're here today talking with the attorneys over at JK Closings. We have CJ, it's easier than calling him Charles. He is one of the owners, and we have Nick, he's one of the associate attorneys, and they are awesome. They answer their phones, you call them, you get them, like, you know, this is what you're looking for. I hear a lot of horrors and nightmares about, like, you know, hiring attorneys, and this isn't one of them. So we just talked about the new foreign national entities and how that's affecting everyone, and we can go on for that for probably a while and you still won't understand it. So just make sure that you're hiring the right realtors and the right attorneys to make sure that you're not getting in a scenario where you in the end are going to have a deal that's been canceled. The other thing that's coming on right now is that we have new condo laws coming in regarding reserves. So what are those laws, and what do we need to worry about as realtors and as owners of condos? And does that affect two-story condos, three-story condos? Like, what does that look like? So, guys, tell me, like, what do you know about this?
You want to go?
You know anything?
Okay. I don't know anything about condo law.
Well, there's two different things that associations, especially condo associations, need to do and control. They need to have a milestone inspection, and they need to do a structural integrity reserve study as to their reserves. What they are is...
Wait, is this for all condos?
This is for, it depends. Each of them has different requirements.
Well, wait, so when did this come into effect? Because let's start from the beginning, because this is like starting to sound like Chinese to me, so...
Yeah, so let's go back to a couple years ago when we had if you're familiar with the Surfside tragedy, a building collapsed in Miami. And so the reaction to that was the state passed a law regarding condos and their reserves. So condos that are 3 stories and higher, they have to have fully funded reserves by the beginning of 2025. And fully funded reserves means that if there is a structural component of the building, like elevators, the exterior of the building and any structural components of the building, and there's a catch-all, anything that costs $10,000 or more to replace, which could be elevators, air conditioning units, things like that. The association has to have fully funded reserves for that, which means they have to have money in reserves to be able to pay for the replacement of those items. So what Nick was saying about the milestone inspection report and the structural integrity reserve study, these reports and studies will show how many years of life left an association might have on, let's say, the roof. And if there's 20 years of life left on the roof, well, then they only have to start accumulating funds to replace the roof in 20 years. But if there's 0 years of life left on the roof, the association is going to have to fully fund their reserves to replace it now, which means that we're going to start seeing a lot of special assessments, which we are already seeing at condos, because they have to fully fund their reserves in order to come into compliance with this law. So the days of these associations kind of waiving their reserve funding and kind of passing the buck onto the next owners and the next generation of that building, that's going to be over. They're going to have higher regular maintenance assessments, and they're going to start having special assessments in order to pay for all of these items.
So what would you advise a buyer if they came into you with a contract, right, today for a condo, and it was 3 stories or more? Let's stay on the beach. Let's use the beach, because there's not many 2-story ones, you know, that are worth buying as much as there is high rises. So we know a high rise is definitely going to need concrete restoration, those kind of things. So if I came in today with a contract saying I was going to buy in one of those buildings, right? Because Pompano is so great right now, and I want to live in a condo where I can walk down there. What would you say to the buyer?
I mean, we would suggest putting language in the contract that would protect the buyer in the event something would come up after the effective date, or if something was, I mean, if something's not disclosed, then the seller would be responsible anyway on the contract. But if something were to come up in the time you go under contract to the time of closing, we can construct a provision for the contract which would protect the buyer and give the buyer the option either to, back out or review the proposed assessments, maybe back out of the contract and then go look for a property somewhere else that might not be subject to such high assessments, because in reality, most of them are going to be subjected to higher dues, higher assessments at all, because they might not have had special assessments. Usually they do. But, so the buyer has to be hyper vigilant and be proactive entering into contract rather than reactive, because at that point they might be stuck.
Well, what is so typically as agents to do, lower down payments, we're always looking for condos that are, 10% in reserves. So in order to be fully funded, what does that look like? Let's say, for instance, they collect $1 million a year in assessments from the entire building. I'm just using a round number, right? And that would mean that every year they need to be putting in, $100,000 into an account. If they're collecting $1 million, right? That would be 10% reserves if they're collecting 10% that year, because it has to be that specific year.
Right.
Now, how do you know what fully funded is if you're a buyer?
Yeah.
So do you know?
I don't.
Okay.
It depends
it
depends on each building individually as to what fully funded actually is, because different buildings have different amounts of units. They have different amounts of stories, and they have different requirements. Some buildings have, 4 or 5 elevators. Some buildings only have 1. Some buildings have multiple air conditioning units on the roof. And it really depends on what each individual building is as to what qualifies as fully funded. So the way that the law talks about this is having line item funding. So let's say you have 5 years of life left on your roof, and it costs $100,000 to replace the roof. If you have zero money in your reserves allocated towards the roof, then you need to start collecting $20,000 a year for the next 5 years to pay for that $100,000 roof. So it may not matter if in your scenario that the building has $1 million in reserves, if none of that money is allocated towards the roof and the roof only has a couple years of life left on it, now all of a sudden that association may have to do a special assessment for the reserves for that roof. Or they might be able to reallocate funds that are in the reserves towards the roof. It depends. So usually if a building has, let's say, $1 million in reserves, they are looking at everything that they have and they're collecting and doing what they're supposed to be doing in accordance with the law already. Where we get into situations with special assessments are these buildings that for years and years have not done any maintenance to their building, and they did not collect for reserves. Yeah. They waived. So, as I'm sure, Laura, you've had clients that will come to you and say, I don't want to pay a lot in maintenance fees for my condo. And so you look at places that have low maintenance fees, but those places are also not collecting for reserves. So those are the places over the next couple of years that are going to have massive special assessments, because to come into compliance with these laws, they're going to have to fully fund their reserves. The places that already have high maintenance assessments and are already collecting for reserves, they're probably not going to have that many special assessments, because over the history of that building, they've been collecting to be able to maintain that building.
Well, we've run out of time. So thank you for coming, guys. Tell me, what is the best number for them, or best website for people to check you out, to get a hold of you when they're ready to think about either being represented as a seller or they're a buyer and they need representation and know that their prices are fair? So what would be the best number to get a hold of you guys?
954-779-5000. You can call or text that number. You can reach out to me and Nick at legal@jkclosings.com as well.
And what they do is that number is always attended by another attorney at some time or 7 days a week. So they're always there to respond to that text. And also somebody is always answering those emails. So it might not be them, but everybody has a round robin. They're more than just them as attorneys in the office, so that they can actually, not be overly worked and well rested, because, busy. So again, if you're looking for a top agent, give me a call, Laura Sanders, RE/MAX Direct, 954-650-0827. And trust me, we definitely saved you money tonight by not buying a condo that doesn't have reserves. So see you next week, guys.
Thank you for tuning in for Making Money with Laura Sanders, a name you can trust. To join the conversation, call us at the studio, 888-994-4995 Studio A, or contact Laura directly at 954-650-0827. Laura Sanders, a name you can trust. We look forward to seeing you next week.